Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Rajya Sabha TV. Today we bring to you the anti-hijacking bill which was tabled in the Rajya Sabha in 2014. To discuss the issue, I have with me Mr. Chandra K.P. Sinha, former Regional Deputy Commissioner, Regulatory Authority of Civil Aviation Security, and Mr. Rakesh Dwivedi, Senior Advocate, Supreme Court. Now for the headlines. Bill proposes death penalty for aiding and abetting hijacking. Definition of in-service of flight includes pre-preparation time and 24 hours after the flight lands. Provision allows residents of India to be extradited for acts of hijacking committed outside India. If any individual tries to hijack Indian planes, he will be sentenced and executed to death and his property may be confiscated forever. The Anti-Hijacking Bill 2014, tabled in Rajya Sabha, proposes strict punishments for acts of hijacking.
The new provisions mentioned in the Anti-Hijacking Bill propose death penalty to those who commit the act of hijacking if found with arms on him, or there is evidence of him intimidating anyone on flight. The bill expands the definition of hijacking to acts like exercising force, intimidating passengers, and usage of new technological means to damage the safety of passengers. Government has proposed the new amendments to comply with the norms prescribed in the Hague Convention in 1970.
Bringing in death penalty is an issue which is a country-based issue where some countries have objected to death penalty, but India has death penalty. India has not said we will not have death penalty, and therefore if it is death penalty is there, definitely it should be there in hijacking also.
According to the provisions of the Anti-Hijacking Bill, seizing of any registered aircraft in service by unlawful means will be considered as hijacking. A person is considered to have committed the act of hijacking when he or she attempts to commit a crime in an aircraft in service, or organizes or directs others to commit such offence, or participates as an accomplice in such offence. The bill also includes acts like assisting another person to evade investigation, prosecution or punishment, knowing that such person has committed any offence which amounts to hijacking. For all such offences, the bill proposes death penalty, where such offence results in the death of a hostage or a security personnel. There is also provision for imprisonment till he completes his natural life, and his property will be confiscated forever.
Again, you see, now if you go by the definition of in-service, as I said earlier, it includes the time before the flight takes off. And at that time, CISF, if it's an Indian airport, CISF will be providing security at that airport. So they would get involved. And I suppose this, all these things have not spelled out in the draft bill.
The bill has expanded the definition of aircraft in service to include its pre-operations on the ground before taking off. These provisions are added by the central government to allow agencies to be accountable in preparing, inspecting and approving flight safety. This includes police forces stationed to protect passenger safety at all airports. Government wants to build up an effective coordination between several agencies involved in protecting airports and aircrafts. By extending the definition in service in the legislation, government is aiming to build that confidence. With camera person Smriti Ranjan, Rajkamal Rao, Rajya Sabha TV.
According to the bill, an aircraft will be considered to be in service from the time it is being prepared for a specific flight by the crew or ground personnel until 24 hours after the flight has landed. Now that's the crucial change. First of all, I'll get you in, sir. Are you happy with the punishment that has been provided in this bill after 15 years of the major hijacking event? Do you think death penalty is really going to be a deterrent for a person who is motivated enough to hijack planes?
Yeah, 100%. I am in favor of such law. And I think this law should have been enacted much earlier. And the deterrent, the word you have used, this is the theory in security, that unless and until there is deterrent effect, nothing will happen. Whatever you do for the security, but deterrent should be there. So 50% security lapse can be avoided if the deterrent effect is there. So this is very good deterrent effect, and it must be implemented at the earliest.
We'll get Mr. Rakesh Dwivedi in. Mr. Dwivedi, you've heard here Mr. Sinha say that deterrent was important. Now, how do you, from the legal framework side, how do you see this panning out? Do you really see it having the effect that it has been provided for?
Well, Indian criminal jurisprudence is used to death sentences, and we must remember that when a plane is flying, hundreds of passengers are sitting, so the very civil aviation is threatened by this terrorist activities of this hijacking activity. So therefore, it is very essential that the law should be very tough and strong against these kind of criminals. So it's a welcome step, but it is important to note that in section 4, which prescribes the punishment, the death sentence is not a mandatory death sentence. There is an alternative of imprisonment for the remainder of the life. So that's a discretion with the designated court.
Sir, don't you think that...
It balances the...
Yes, sir, carry on.
It balances the roles of various people who are associated with the particular crime, and death sentence can be given to those only where the result is of causing of death of the people in the plane.
So if there is a situation where there is intimidation that has happened, there is hijacking of plane, and all the possible worst things have been, crimes have been committed, but a death does not happen. So do you see these hijackers being given the second option of imprisonment for life, for entire life, and confiscation of property? Is that the possible go by?
Yes, if that is right. If no death is caused in the plane, then the likely sentence is to be the other alternative, namely life imprisonment for the remainder of life.
Right, sir. Mr. Sinha, so you...
This is a small distinction with ordinary law. Life imprisonment...
Yes, sir, carry on.
Need not be for the whole of the life, but under this it is for the remainder of life. So this is another change.
Basically, you say that the death has been kept there as a deterrence.
Yeah.
And the law says that it will only happen if a death is caused on board or during the process of hijacking.
Yes.
If that doesn't happen, then imprisonment for the remainder of the life, that will be the second option that will be exercised by the judiciary to punish him. Now, is that satisfactory?
Yes, yes, correct. If the crime is not of that much importance, the life imprisonment is also.
Hijacking has happened. Everything has happened.
Yes. But first of all, it should be death so that it will have much effect as a deterrent.
Okay. Second point I'll get you in is the expansion of in-service.
Yeah.
Definition expansion of in-service. Now, that includes pre-preparation time of the flight and 24 hours after the flight has landed.
After the completion of the
flight. Now, here, the entire security apparatus now comes into a loop of the ambit of this law.
Yeah, correct.
Do you see that really as a step in the positive direction, or is it a deterrence for the security apparatus?
100%. This is a positive step. It must have been done earlier also.
How? How do you think will it impact the security apparatus? Because you're bringing in CISF personnel, the aviation security authorities, and other government staff also under the ambit of this law. So if anything, one lapse from their part is going to make them accused.
But as per our Bureau of Civil Aviation Security, the norms is that whosoever is working inside or even related with the aviation operations, they are given mandatory training, supplementary training, a briefing, some sort of security briefing, whenever they are working in the airport, they are even, we used to give training even to the vendors and salesmen also, that you should act as ears and eyes of the security agencies.
In case there is a human lapse. After all, everyone is a...
Lapse is...
but that brings him into this ambit of law.
No, if it is lapse intentionally, then he can be. But if intention was not there, he should not be punished.
We'll get Mr. Dwivedi. Mr. Dwivedi, the definition of in-service has been expanded to include the security apparatus and the security setup all around the airport. Now they come into the ambit of this law. Do you see this as a positive step, making the security officers more vigilant and more, duty bound and more effective on ground so that they are not brought under this law?
You see, there is a little misconception. The security personnel will ordinarily not come within the scope of this act, and they will not be found guilty of hijacking crime, because normally they are not expected to be aiding intentionally. The very important expression is that they should be furthering, abetting the crime. So abatement, etc., these are all intentional. And once a security personnel or anybody in this society, if he is aiding or abetting, then he is surely within the net of the crime, and he needs to be punished. So it is nothing great and nothing no different from the ordinary law. If he is abetting intentionally, only then he will come. So there is no need for any scare that because of this change in definition, the security personnel will necessarily come into the net of this crime.
Because this point was made by a former cabinet secretary, Mr. Ajay Prasad. So that is why we are trying to understand that whether it will really have an implication. But what I'm trying to bring
no, that is wrong. That is absolutely wrong. There is no need for scare.
Okay. Now the second part is the grant of bail. Is that a regular feature, or do you see something new in this?
So far as the provision of bail is concerned, we have similar provision in this TADA and other serious crimes, Makoka and all that. So whenever there is some offences like terrorism or hijacking is another kind of terrorism, we have such stricter provision for bail. And the provisions do suggest that there will be no scope for any interim bails. The prosecutor has to be heard, and only thereafter the court will consider whether regular bail has to be granted. And there also the designated court has to be satisfied that the person is not guilty. So therefore there has to be strong evidence of his innocence.
Right, sir. Time for us to head into a break. When we come back, we will talk about the provisions for extradition. Welcome back. For the first time, the government has included a provision of extradition. This provision allows residents of India to be extradited for acts of hijacking committed outside India. The bill allows the courts to presume the accused as guilty of hijacking if the officer proves that arms were recovered and intimidation happened on board.
Any officer authorized by central government will have the powers of investigation, arrest and prosecution in matters relating to hijacking. New provisions mentioned in the Anti-Hijacking Bill allow an investigating officer to order seizure or attach property related to the offence, where he apprehends concealment or disposal of it by the accused. The officer has to establish that the properties recovered were used by the accused in hijacking.
The magnitude of the situation would be such that individual state governments may not be fully equipped to handle the situation. So I do suppose that NIA will be interested with that, and then they will evolve their own modus operandi and the methods of investigation. And
As per the provisions of the bill, no accused can be released on bail or on bond unless the public prosecutor is given a chance to oppose the release or the designated court is satisfied that the accused is innocent and is unlikely to commit such offence while on bail. The bill allows all Indian courts to exercise jurisdiction on act of hijacking committed in India, in an aircraft registered in India, against any Indian citizen and a citizen present in India. It also empowers courts to allow detention of accused up to 30 days if investigating agencies fail to complete investigation in 24 hours.
What happened in 1984 in Afghanistan? The countries who don't ratify, they are not part of the whole system, and therefore if a hijacker lands up there, he will definitely get protection.
The bill allows extradition of those accused in hijacking as offences relating to hijacking have been made extraditable. Anti-Hijacking Bill 2014 was introduced in Rajya Sabha in December 2014 to give effect to the Convention for the Suspension of Unlawful Seizure of Aircraft 1970 and its protocol supplementary signed on September 10, 2010. Experts in the aviation sector want the government to give clarity on which department will authorize an investigating officer to conduct any kind of investigation. As on today, the bill do not have any specific provision to identify that particular department. With camera person Smriti Ranjan, I am Rajkamal Rao, Rajya Sabha TV. Extradition is a new element in this entire bill. It's a new provision. So, getting you in here, Mr. Dwivedi, what do you feel? This is completely new for the first time?
Well, that is true, but we already have the Extradition Act operating in the country. That is since 1962. And it has been extended to this kind of an offence, which is very rational and understandable because more than one country are involved, and the people of more than one country may also be involved in the commission of crime. So, all that has been taken into consideration, and this is applicable by virtue of the convention, the Hague Convention. So, it's an understanding which has been globally arrived at. So, it is appropriate. There's no harm in that.
Okay, I'll ask you this question, Mr. Sinha. What happens in case Afghanistan, case like Afghanistan happens, which earlier happened, the big hijacking case. Now, if Afghanistan is not a signatory to this convention, then what happens?
Then I think we cannot do anything.
So basically, what we have done is we've allowed the other countries to seek extradition for an accused who's in India.
Yeah.
But if there is an accused in Afghanistan or Pakistan or Nepal or Bangladesh or Sri Lanka, then India will not be able to seek their extradition. Is that correct?
Yes, yes.
So what is the purpose of this one-sided extradition declaration?
I think this is a legal matter and I may not be appropriate to say about this. But this should be included if it is possible.
Sir, the point I was asking is, you said that signatories to the convention will be able to extradite and things like that. But let's say there is a situation where the country like Afghanistan, Nepal, Sri Lanka, Pakistan, these are countries and the accused is in this country. And if they are not signatories, what happens then?
Yes. Well, if they are not signatories, then there will have to be bilateral negotiation with these and talks with those countries and to get them extradited, and it will depend upon the success of those talks and negotiations.
So which it means this law will have to lead into another engagement and bilateral understanding between the countries.
That is logical. There is no other way out because the two countries must agree to such an extradition. Only then there can be extradition.
Yes.
But as of now, we have included extradition. So what happens is a person residing in India and is accused of hijacking anywhere outside India will definitely be able to be sent to that country. So that is possible now. It could be possible.
No, if those countries are not signatories to the convention, then we need not extradite them.
So, all countries
For example, if the person is in Afghanistan or Bangladesh, and if they are not part of the convention, if they are not agreed to this reciprocal arrangement, then we can refuse to extradite them.
Correct. Second is also the onus of proof. Here two things have happened. The proposed bill says that in case an arm or intimidation evidence is available with the prosecuting agency, then the onus of proof shifts on the accused, and the accused will have to prove that he is not guilty. Now, this shift, is it new or has been there for quite some time?
No, these kind of provisions are also there in several laws, and when there are certain evidences which are established, then the onus shifts to the accused. It happens in normal accusations also. So it is nothing very strange, especially in hijacking. If you are carrying an arm, then such a presumption is being raised, and then the accused has to establish why he was carrying those arms. Has it any connection with the crime? Or he will have to show that it is not connected with any intent to commit crime of hijacking.
On the issue of bail, it's clearly stated that prosecution will be given a chance to oppose first. Once the prosecution has made an opposition, then the judge will take a call and can take a call to grant bail only if he is satisfied that the person will not commit the same crime after he is on bail. Now, leaving it to the wisdom of the judges, do you think that is really going to help? And any judge will put his neck on the line and grant bail?
Well, in a judicial system, first of all, there is no other option except to trust the wisdom of the judge in the exercise of the discretion, and he is expected to act in a reasonable manner. And more than that, if he commits any error, then there are provisions of appeals. The accused can go to the High Court and then come to the Supreme Court. So there are all checks and balances there. So there is no difficulty in that. The accused can certainly produce evidence to show that he is not likely to commit the crime.
So first level,
of course, it will be a difficult proposition, because once you are involved in a hijacking crime, it will not be easy for him to establish that he is not likely to commit it again.
So basically in a roundabout manner, the judiciary at the lowest level has been told or indicated that if you want to do it, do it at your own risk.
Yes.
And provide, enough, evidences with it, and then you can grant bail. Do you think ever bail will be?
No, it's not. No,
Yes, sir.
No, it's not. It's not that way. The question is, the crime is very, very serious. The whole aviation commerce proceeds on the footing of that there is safety and security.
So practically bail will be difficult.
From the fact that normally the state is charged with a duty to secure the life of the people.
So practically bail will be...
Therefore, it's a serious matter, and the court will have to look at it seriously.
Right, sir. Right, sir. Moving on. My colleague Rajkamal Rao spoke to Mr. Arun Chaudhary, former Special Director General CISF Airports, and tried to get his perspective.
Since it is going to be a federal law, a federal investigating agencies should be involved in actual investigation of these crimes. The NIA, as a new body which has come, is doing a good job against crime which is related to terrorism. Hijacking is an extension of a terrorist act. And I think NIA, over a period of time, in a short period of time, has achieved that type of professionalism in which they can really investigate the hijacking case. Plus the fact that in this act itself, all the police forces of the states, all the central police organizations, if they have come to know about these, somebody involved in this, then it is incumbent on their part to help the NIA in its investigative, efforts. So that is a very composite thing which has been brought into this act.
There is a provision which expands the definition of hijacking, which includes in-service operations. What is the impact of this particular provision, sir?
Today we have to be much more preventive than catching hold of the executors. So the stakeholders, like for instance in our country, like the CISF, and then the airline security, and the checks and things which they have to do before you board the aircraft is absolutely very essential.
Thank you, Mr. Dwivedi, for joining us, and thank you, Mr. Sinha, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.